morning, and you're all very welcome to our special webinar on the impact of the Digital Services Act on startups. My name is Martina Fitzgerald, and I'm the CEO of Scale Ireland, which represents, supports, and advocates on behalf of Indigenous tech startup and scale-up companies. And there are currently 2,000 tech startups right around the country employing 47,000 people. So this is of huge interest to a lot of people watching in today. And we are delighted that Minister Troy can join us in studio here in Dogpatch Labs for this special webinar on the proposed new regulation, the Digital Services Act, which really applies to digital services that transmit or store third-party content. And today's event, which is supported by Google, will run for an hour, and we're going to get feedback from founders and startups around the country. And you can submit your questions via the chat room on your screen. Now, in terms of the format, I'm shortly going to hand over to Brian Caulfield, our chair. Then we will hear from the Minister. And we're also delighted to be joined this morning by Claire Morrisey, the Head of Commercial Data and Technology at the Maples Group. And Scale Ireland commissioned independent research to see exactly what the impact would be of the Digital Services Act on startups. And Claire is going to bring us through her research and her report. So we're delighted to get the opportunity to share that with everyone today. And then there will be an opportunity for questions to Claire. So again, submit those via the chat room. So without further ado, I'm going to get proceedings started and go straight over to our chair, Brian Caulfield.
Thank you, Martina. I've spoken before about the vision for Scale Ireland. In 2019, myself, Liz McCarthy, and Patrick Walsh of Dogpatch Labs came together and founded Scale Ireland because we wanted to ensure that Irish startup and scale-up technology companies had a strong voice and were being promoted and supported to reach their full potential. We wanted to make Ireland a leading location for innovation and entrepreneurship in the same way that we've made Ireland a leading location for foreign direct investment. So I'm delighted to see the level of engagement that we're getting from government. In the past 8 months alone, we've hosted events with the Taoiseach Minister for Enterprise, Trade and Employment, Leo Varadkar, Minister for Finance, Pascal Donoghue, and now with the Minister of State at the Department of Enterprise, Trade and Employment, with special responsibility for trade promotion, digital and company regulation, Robert Troy. That engagement reflects the increasing importance of Irish startup and scale-up technology companies and has been driven by Scale Ireland's success in building a community of 800 startup CEOs and founders. Earlier this year, we successfully launched a membership model, which I want to plug mercilessly once again. The voices of the startup and scale-up tech community need to be heard because this sector has an enormously positive story to tell and an important contribution to make in the coming years to our economy and to our society. We've concentrated very much on the issues that face the sector in terms of accessing finance, recruiting and retaining talent, and incentives and disincentives to entrepreneurship. But regulation can also have a huge impact on startup success. It's crucial that startups have timely access to relevant information on new regulations, such as GDPR and DSA, to help them to understand the impact on their business, to prepare accordingly, and where necessary, to feed back concerns to government. This event is very much part of that process. I'd like to thank Minister Troy for joining us this morning. I know that it's a very busy time for ministers with the Dáil having recently resumed, so I'd like to thank him for taking the time to join us, and with that, ask him to give us his opening remarks.
Thanks very much, Brian. And can I start off by thanking Brian, your chairperson, for the work he's doing with our department in relation to the SME task force. He has been an invaluable asset to the task force over the last 12 months, given of his time voluntary, and we appreciate that. And to Martina, it's great to be here with Martina. I know Martina a good few years now, and I think you're very fortunate to have somebody with the passion, commitment and work ethic that Martina has displayed over many years as your new CEO. So I wish her well in her role here. I think, you know, the opportunity to open today's event, which has been designed to look at the implications of the Digital Service Act in terms of what types of Irish startup companies will be affected, their obligation under the Act, and what this will mean in terms of resources and costs. As part of the European Digital Strategy, Shaping Europe's Digital Future, the European Commission published its proposals for a Digital Service Act. This proposal seeks to ensure the best conditions for the provision of innovative digital services in the internal market, to contribute to the online safety and the protection of the fundamental rights, and to set a robust and durable governance structure for the effective supervision of providers of intermediary services. In particular, the proposal establishes a framework for the conditional exemption from liability of providers of intermediary services, rules on specific due diligence obligations tailored to certain specific categories of providers of intermediary services, and rules on the implementation and enforcement of this regulation, including as regards the cooperation and coordination between the competent authorities. The core principles of the current e-commerce directive, in particular, the country of origin principle, has been maintained and developed, allowing businesses a degree of legal certainty as to their responsibilities. The DSA proposal sets asymmetric due diligence obligations on different types of digital service providers, depending on the nature of their services and their size. This is intended to mitigate against disproportionate burdens. It sets obligations for providers of 4 categories of online services: intermediary services, hosting services, online platforms, and very large online platforms. Each of these categories is a subcategory of the one that it precedes it, and must comply with additional obligations. While still being a horizontal instrument, this proposal is heavily weighted towards the very large online platforms, defined as platforms with 45 million users or more in the EU. It recognizes that very large online platforms have a central systemic role in facilitating the public debate and economic transactions, and consequently must be subject to additional substantive obligations. This is aimed at assuring that due diligence obligations are proportionate to the ability of the companies to comply. Micro or small enterprises are exempt from the majority of obligations, and the additional obligations imposed on online platforms under the regulations do not apply to them unless the reach and impact is such that they meet the criteria to qualify as very large online platforms under this regulation. The Digital Services Act will lift unnecessary legal burdens, fostering a better environment for innovation, growth, and competitiveness, and facilitating the scaling up of smaller platforms, SMEs, and startups. The regulation will avoid imposing costs of complying with 27 different regimes in the single market. This will be particularly important for innovative SMEs, startups, and scale-ups, which will be able to scale at home and compete with very large players. It will make the single market easier to navigate, lower the compliance costs, and establish a level playing field. A common, horizontal, harmonized rulebook applicable throughout the digital single market will give SMEs, smaller platforms, and startups access to cross-border customers in their critical growth phase. By rebalancing responsibilities in the online ecosystem according to the size of the players, the proposal ensures that the regulatory costs of these new rules are going to be proportionate. The European Parliament and Member States will discuss the Commission's proposal in the ordinary legislative procedure. The Commission has set an ambitious schedule to have both proposals adopted within 18 months. Ireland is an active and persuasive participant in the negotiations. We are keen for this proposal to be pro-enterprise, pro-innovation, pro-consumer, pro-effective and proportionate regulation. We are pleased to see the phased approach to the application of due diligence obligations within the regulation and the protection from excessive administrative burden being placed on smaller businesses which are less able to shoulder it. This aspect of these rules, balancing protection for the users of digital services with the ability to innovate, will provide a real level playing field for all stakeholders involved. I look forward to the continued engagement with relevant stakeholders, including Scale Ireland, on this significant piece of legislation. And I want to reassure people on the webinar today that we have an open door policy within the department, and we are and will continue to keep in close contact with key stakeholders like Scale Ireland as these discussions evolve over the next weeks and months. And thank you for the opportunity to address you this morning.
And thank you, Minister, for coming into us today and for engaging with us on this critical new proposed regulation. And as you said, there are some of the positives in relation to harmonisation of the rules across the EU. Also, you stressed that obviously the rules to apply to different startups and companies depending on their size and category. And thankfully, to bring us through all the nuts and bolts of that, and that is not a small task, is Claire Morrisey, the Head of Commercial Data and Technology at the Maples Group. Claire, over to you.
Thank you, Martina. And thank you for inviting me here this morning. It's a pleasure to be here to talk about the Digital Services Act, and especially to hear the Minister's thoughts on the Digital Services Act and Ireland's approach to the negotiations on the Digital Services Act on the European stage. Before I get into the heart of the presentation on the Digital Services Act, I just wanted to take a minute to recognize that the majority of people that have tuned in or are watching this online are you are startups. Probably the last thing you want to be doing on a Tuesday morning is listening to us talk about draft legislation. But hopefully this morning's presentation will save you the time of having to trudge through 70 odd pages of draft legislation. Scale Ireland commissioned this paper on the Digital Services Act and organised this morning, as Brian mentioned, to ensure that you're aware of what's potentially coming down the track and what this means for your business. Before we get into the slides, I wanted to leave 3 key messages with you. The first of these messages is, does the regulation apply to you? If it doesn't apply to you, then we can move on. The second key message is that there are positives. The Minister mentioned the liability exemption continuing from the existing regime. This is a good thing. And then finally, this regulation has teeth. There are consequences of not getting your compliance measures in place once the legislation is actually passed. So turning now to the slides, as the Minister mentioned, the Digital Services Act is part of the broader European digital strategy. There are 2 prongs to this strategy, and both prongs, draft legislation, were published in December of last year. One is the Digital Markets Act and the other is the Digital Services Act. It's important that we mention the Digital Markets Act so that we're giving you a holistic picture of the changes that may be coming down the tracks. The Digital Markets Act is focused on promoting competition. It's going to impact the big tech companies, Google, Apple, Amazon, Facebook, Microsoft, most. It's designed to promote greater competition in the digital environment. So, for example, it imposes obligations on the big tech companies to ensure that their service recipients can uninstall pre-installed software. So you're not tied into the relevant tech providers' software. It has provisions to promote to ensure that your systems are interoperable. And it has provisions on increasing advertising transparency. On the other side of the coin, and the side that we're focused on today, is the Digital Services Act. The Digital Services Act is focused on creating a safer digital environment for all users, for the end user and for the businesses operating in that digital environment. The law in this area hasn't been updated in the last 20 years. So the current regime is governed by the e-commerce directive from 2000. It's time for an update. The online world and the real world have changed quite a lot over the last 20 years. In line with the theme of being focused on creating a safer digital environment, the DSA is focused on illegal content and ensuring that illegal content is removed from the online world. In terms of the timeline for this strategy, the minister mentioned that there's an 18-month trajectory, which is quite an ambitious timeline. The proposals were published in December 2020, which means come June of next year, we should be looking at finalized proposals. However, with European legislation, it often doesn't go to, it doesn't stick to the timeline originally anticipated. If we look at the GDPR, that took years and many, many different versions of the actual regulation before it was finalized. In terms of the DSA, the Portuguese presidency published a compromise text in June, so an updated version of the DSA. And we can see from that compromise version that there are a lot of things that still need to be finalized. And some of these potentially have a great impact for startups. And when I get into the heart of the various obligations, I'll point out some key areas where you really need to be or want to be mindful and engaging with Scale Ireland to ensure that the obligations remain proportionate to the nature and size of your business. So in this part of today's session, we're going to cover three things. Firstly, who's in scope? Secondly, what does it mean to be in scope? And lastly, how will the regulation be enforced? The regulation applies to intermediary service providers. We'll look at who intermediary service providers actually are. What does it mean to be in scope? Broadly, you continue to benefit from the existing liability exemption, and I won't go into I'll leave the detail for the rest of that section, and similarly on the enforcement provisions. So turning to who's in scope, this is the most fundamental question for the whole topic on DSA, because it determines the relevance of this legislation to your business. So who's in scope? It applies to certain intermediary service providers. There are three categories of intermediary service providers that it applies to. Firstly, mere conduits. Secondly, those who provide a caching service. And thirdly, those who provide a hosting service. What are mere conduits? Mere conduits are businesses that pass information between the sender and the recipient over a communication network. Caching involves the automated temporary storage of information to smooth the transmission of that information. And lastly, hosting. Hosting is simply the storage of information provided by and at the request of a recipient. That's not the end of the story, and we'll look at some examples of businesses that fall within each of these categories. The other part is that the DSA will apply to all services provided within the EU. So it applies regardless of where the service provider is established. For example, it will apply to a US business that is providing hosting services to EU data subjects. This is positive for European startups as it ensures that non-EU counterparts are bound by the same level of regulation in this particular space. i.e., it should mean that there isn't a competitive advantage from a digital services regulation perspective of establishing outside of the EEA. Now, there is a question, and this question often arises in the context, for example, of the non-territorial application of the GDPR as to how would the EU data protection authorities actually enforce against a non-EU entity. And this is one of the issues that is part of the current discussions on the draft DSA at the European stage. But it is important that the principle is there, because if we didn't have the principle that it applies regardless of where the service provider is established, well, then we would potentially end up with a greater regulated environment within the EU and a competitive disadvantage for EU startups. So who's in scope? Hosting, of the three categories, hosting is probably the category that will affect the majority of the attendees here or listeners to this webinar. The impact assessment for the DSA divided hosting into three broad categories: storage and distribution, network, collaborative production and matchmaking, and selection, search, and referencing. So within this, we've got web hosting, online media platforms, file storage, social media and discussion forums, online marketplaces, search tools, reviews, and ratings. And again, to try and make this a little bit more real as opposed to just phrases, here are some of the household names that we'll all know that will fall within the scope of the DSA on the basis of some part of their service offering. So as you can see, just from the concept of hosting alone, the wealth of businesses that are potentially caught is really broad. There is, however, some complexity around this piece of who's in scope and who's out of scope. So the DSA doesn't apply to a service that is not itself an intermediary service, even if it's provided through the use of an intermediary service. So for example, if you're using AWS hosting services, but you yourself are not providing hosting services or other intermediary services, you're not going to fall within the scope of the DSA. So this is almost a double negative. Where's the dividing line between who's in scope and who's out of scope? I thought it'd be useful to briefly mention two recent Court of Justice of the EU decisions to illustrate how the dividing line can be different, even though on the face of it, the two services seem to be quite similar in terms of the intermediation services provided. So the two cases here are the UberPop case and the Airbnb case. In these cases, the Court of Justice was asked to consider if the services provided by Uber and Airbnb amounted to automated intermediation information society services. And I know that's probably a bit of a mouthful, but let's ignore the technical jargon and we'll look at the facts, which will bring it to life. And I think the key point for me is that the court came to different conclusions when it looked at both of these services. In UberPop, Uber was providing an app in France for people to book rides with non-professional drivers in the driver's own cars and for payment. In that particular case, the court said this is not an information society service, even though the service was booked on an app at a distance and it was provided for remuneration. The court took the view that the Uber intermediation service was such an integral part of the overall service being a transport service, that actually when you look at it as a whole, it was a transport service and not an information society service. So contrast that with Airbnb, where the court concluded the Airbnb services were or are information society services. What's the difference? Airbnb provides a platform for guests to book accommodation with hosts, yet that was held to be an intermediation service and not an accommodation service. Some of the distinguishing factors which the court looked at included the influence that Uber exercised over the conditions on which the transport service was provided under the app. So with UberPop, Uber set the maximum prices, it took payment from customers, it controlled the quality of the vehicles, and it has exercised some control over the drivers as well. The court also focused on the fact that without the UberPop app, individuals wouldn't have been able to book this service and the relevant drivers wouldn't have been able to provide the service. In contrast with Airbnb, the court said, this is an accommodation service. People don't have to use Airbnb to book this service. There are many options available to people to book the service. And while Airbnb offered additional ancillary services to host, like a photography service and a civil liability insurance, they were not such an integral part of the service that the whole of the service should be viewed as an accommodation service. So I hope those two cases, the contrast between them, serve to illustrate that there is some complexity and mileage, I think, in understanding whether or not you come within the scope of the DSA. So what does it mean to be in scope? It's not bad news if you're in scope. There are clear positives to being in scope. Now, benefiting from those positives will bring some compliance cost, but with everything, there's a risk-reward cost benefit to it. So turning now to the actual benefits. And the main one, the one that is really trumpeted in all of the papers about the DSA, is this harmonization. It's intended to remove the costs of legal fragmentation. So scaling up startup businesses having to comply with 27 different regimes in relation to takedown notices and dealing with illegal content. It's harmonizing the procedures for dealing with those types of requests, as opposed to actually harmonizing the law on what is illegal content. So certainly the principle is there that there should be a reduced cost resulting from harmonization, from reduced legal fragmentation, but it will remain to be seen whether that is in fact the reality, and I'll touch on why that is in a couple of minutes. So associated with the first benefit, again, is the idea of improved legal certainty and predictability, increased transparency around content moderation, recommending and advertising systems, increased transparency of potential business wrongdoers, and ultimately protection of the fundamental rights of users and the protection of content. Because again, what's the DSA all about? It's about making the digital environment a safer place for users and businesses. And we'll look at how some of these benefits arise when we look at the obligations slide, which is coming up later. Again, just focusing on what does it mean to be in scope of the DSA. And we've touched on, the Minister has touched on this already. The DSA continues the existing e-commerce liability exemptions for providers of intermediary services. What does this mean? It ultimately means, provided that your caching, your mere conduit, or your hosting service comply with certain conditions, they're not liable for the content that is that their service recipients put onto the service provider's service. So, for example, a hosting service provider will not be liable unless they have actual knowledge of illegal content, or they don't take expeditious action once they become aware of illegal content. Second benefit, there's no general obligation to monitor content or actively seek out circumstances indicating illegality. This is a real plus for startups, because you really are unlikely to have the funding, the people, or the technology to monitor content on your service on a 24/7 basis. And presumably you want to be spending your time and effort on making your product better rather than looking at what's up there. Thirdly, and this is a really positive part, you won't lose the benefit of the liability exemption because you voluntarily take actions to protect your users. This is known as the Good Samaritan provision. The combination of these provisions should give startups better opportunities to scale safely, both for them and their service users. So turning now to the costs of compliance. You have new obligations. Before we look at these particular obligations, there are some structural points that we wanted to, that's important that we kind of set the scene for those structural points. And that is that the obligations here are graduated. They're largely determined by reference to the size and nature of your business, and it's aimed at ensuring that your due diligence obligations are proportionate to the ability to comply. So Section 1 obligations apply to all intermediary service providers. Section 2 only to hosting providers. Section 3 to online platforms, and Section 4 to VLOPs, or very large online platforms. Okay, so there's a hell of a lot of information on this slide. You don't need to take it all in. Don't try to rush and read it. I'll take you through the important points for you. And as a startup, it's the top half of this table that at the moment is important for your business. So you'll see we've got including MSEs there and excluding MSEs in the various quadrants of this box. And the including MSEs is including micro and small enterprises, and the majority of our startups will fall within that category. So where you see excluding MSEs, that's really positive. It means you don't have those obligations, and you don't have to be concerned with them. However, a caveat on this needs to be kept under review, because there are changes as the legislation is going through the European Parliament. For example, the European Commission is advocating that some of the Section 3 obligations would also apply to micro and small enterprises, so would apply to startups, and this would potentially significantly increase your compliance costs here. So this is something that, you know, it's important to keep an eye on and ensure that Scale Ireland is aware, you know, that you do not want the obligations in Section 3 to apply to startups. Let's put a bit of flesh on the bones here and look at what does apply based on the current legislation. So looking at the top left-hand quadrant, all intermediary service providers have to provide a point of contact for regulators. In your terms and conditions, you need to provide information on restrictions in relation to information. So it's almost equivalent to your acceptable usage policy. What information can people put up on your service? You have to provide information on your policies, procedures, and tools for content moderation in your terms and conditions. You can ignore the legal representatives and the transparency reporting obligations in this quadrant, because legal reps applies to businesses that are not established within the EU, and I'm assuming that the majority of people listening this morning are established within the EU. And oddly, the transparency reporting obligations exclude micro and small enterprises. So that's a positive. Looking then at hosting services, so that long list of types of hosting services that we looked at, if you are a host service provider, you'll have to comply with the Section 2 obligations. What are the Section 2 obligations? You need to have a procedure in place for people to provide notice of illegal content, and for you to take action in response to those notices. The notices need to provide information, so the person submitting the notice of the illegal content needs to provide sufficient information to enable a diligent internet service provider or hoster to confirm whether or not, in its view, the content is illegal. There aren't time limits around these obligations. They have to be complied with without undue delay, and as I mentioned, you have to act in a diligent, objective, and proportionate manner. This is positive that you have leeway as to the timing around compliance. You know, if you contrast it with the 72 hours in the GDPR, by which businesses have to report their security breaches. So also another obligation that you have in the hosting services, and that's an obligation to notify authorities where you are aware of suspicions of criminal offences impacting life or property. And this is an obligation which previously fell on online platforms as opposed to host service providers. But again, in the moving regulation, that obligation has moved up to host providers. Just briefly to touch on the bottom half of this table to give you a sense of, you know, what we mean when we talk about asymmetric obligations or proportionate obligations. If you're an online platform that's not a micro, small enterprise, you need to put in place an internal complaint handling system for recipients of your service who don't agree with your takedown or your response to a notice. You need to provide them with an you need to essentially agree to an out of court dispute settlement procedure. You need to take action promptly from trusted flaggers, and trusted flaggers will be designated by the local digital services coordinators. There are transparency reporting requirements, so that these transparency reporting requirements require an annual report on the number of content moderation requests and the actions taken. And there needs to be transparency on online advertising. So who is the online advert being advertised on behalf of? And what were the parameters used to select the decision to serve that ad to the relevant user? The Portuguese compromise draft has also introduced this concept of online marketplaces, which wasn't there previously, and has shifted some of the obligations to apply only to online marketplaces. And maybe it might be worth just taking us a minute. What's the difference between a host provider, an online platform, and an online marketplace? A host provider simply stores the data. An online platform allows for the storage and the public dissemination of that data. And your online marketplace allows for individuals and businesses to conclude contracts on the online marketplace. Turning now very briefly to the obligations of very large online platforms. They have to carry out risk assessments. They have to look at mitigations of those risks. They have to subject themselves to independent audits. They need to give information on their recommender systems, and they need to provide additional information on online advertising. So there's quite significant obligations for your very large online platforms, and also for the online platforms. Turning now to something that you've probably all been asking yourself, well, what is a micro small business? Who falls within those particular exemptions? A micro small business is a business with less than 10 employees and less than 2 million turnover. Small, you're into 10 to 49 employees and less than 10 million. And then that's really the defining criteria for, you know, the Section 1 versus the Section 2, 3 obligations. Your VLOPs are organizations that have 45 million active users. And I suppose one of the potential disadvantages of the DSA that's flagged in the context of startups is that when you pass from that threshold from micro small to medium, that the regulatory obligations may be seen as a disincentive to scaling up to the above 10 million threshold in terms of turnover. But hopefully the compliance obligations aren't going to be enough to disincentivize growth of a successful business. The European Commission's impact assessment in terms of the cost to medium-sized businesses of compliance with the DSA notice and takedown procedures, they estimated it at approximately 400,000 per year. So presumably, you know, cost benefit analysis again, businesses will actually go ahead and scale. So what are the startup challenges? The first is your business in scope? Definition of an intermediary service provider. Which side of the line does your business fall? Are you an Uber Pop or are you an Airbnb? The costs of notice and takedown procedures. So the European Commission's impact assessment on the DSA estimated that the cost, a one-off, that you know, the smaller businesses would incur a one-off cost of somewhere between 1,500 and 50,000, depending on the volume of takedown requests. Second challenge is the definition of illegal content. The regulation defines illegal content as any activities that are illegal under EU or member state law. And what this means is that as a business operating across multiple member states, you need to understand what is illegal in that particular member state. So that part is not harmonized. And part of the thinking, the current thinking, is that what is illegal offline should also be illegal online in terms of informing this concept of illegal content. I mentioned the scaling issue when you go over and into the medium-sized business category. The other challenge are current member state regimes. So, as I said, harmonization is the word that is really bandied about in the context of this DSA. However, some member states are in a race to get their own regimes in relation to illegal content and takedowns on their statute books before the DSA is passed. For example, Germany requires networks to remove obviously unlawful content within 24 hours, and there are potential fines of up to 50 million for non-compliance. France tried to adopt similar legislation to Germany, but it was held to be unconstitutional, and they were forced to pass a simplified reporting procedure for illegal content. Poland has a draft law on the books, but that's also encountering some problems as it's going through their legislator. And then finally, I think no discussion would be complete without a mention of the United Kingdom. It's no longer a member state, obviously. So it's putting through its own regime for dealing with illegal content. And this is probably, very relevant for most of you on attending here as you scale, because the UK common language, it's one of our, if not one of our largest trading and countries. So you'll be looking at compliance burdens in the UK as well as the EU. Turning now to the last part of this session, how will it be enforced? The enforcement model is a hybrid model, and I think we can see the legislators here learning from their experience with the GDPR over the last 3 years. So each member state needs to appoint a digital services coordinator. The DSC will be responsible for supervising intermediary service providers established in their member state and for coordinating within their member state. This retains the country of origin principle that the Minister mentioned, and which is at the heart of the current regime. It ultimately, or essentially, means that internet service providers are regulated by the digital service coordinator of their place of establishment. There are, however, exceptions to this principle. The Commission has a role to play. The Commission can intervene where a national digital service coordinator has not acted within the timeframe laid down by the DSA, and the Commission can ask the relevant digital service coordinator to take particular acts. In addition, the Commission will regulate flops. And you can see this potentially as a reaction to some of the bottlenecks that are being experienced with the GDPR enforcement today. There will be a European board for digital services, which will support the Commission and the national digital service coordinators in their roles. So turning to penalties, I guess maybe this regulation wouldn't be getting as much airtime if there wasn't provision for significant penalties under it. So there can be fines of up to 1% of annual turnover for false or misleading information, and fines of up to 6% of annual turnover where organizations don't comply with their other obligations. The fines, obviously, this allows the fines to be scaled to the size of the relevant business, but a fine based on turnover is still going to hurt your business, even if you don't have a very large turnover in your early days. Oops, sorry. Sorry, giving away the last pieces. Okay, some final thoughts. The most important question here is, are you in scope? If you are, there are positives. Will harmonization be real? Will the benefits of harmonization be realized in your business on a day-to-day basis? Will you see that reduced cost arising from reduced legal fragmentation? The new obligations will impact some businesses more than others, so it will have a greater impact on host providers, it'll have a greater impact on online platforms, and obviously it'll have a very big impact on flops. The DSA shows in its provisions that it's mindful of the limited resources available to startups when compared to flops. The obligations that are in the DSA will require startups to plan and review existing policies and procedures. You will need to incur some expenditure to ensure compliance, and you'll need to assign staff to the additional roles required for compliance. The DSA obligations are scaled to represent the size and impact of the entity on the digital market, and consequently VLOPs will bear the bulk of the obligations. The penalties based on turnover will allow fines to be set proportionally to the size of your business, and these new obligations will have teeth via those fines. So my concluding message is that if you have concerns about some of the provisions in the DSA, or if you're positive about the provisions in the DSA and you don't want to see startup obligations increasing, act now, engage in discussions with Scale Ireland, and tease out what this potentially means for your business, so that you can try and influence its journey as it makes its way through the European legislative procedures. Thank you.
Claire, for bringing us through what is a very complicated piece of proposals in a very smooth way, and you've made it very easy. But the point is, I suppose, for startups simply wouldn't have the resources to go and get an in-depth look at the legal implications of their obligations and if they even apply to them. Can I ask you a few questions, first of all, because it is based on your category of startup or enterprise. It's also based on your size.
Yeah.
Now, for small and micro, you're okay for most of the obligations. You simply have to get a point of contact and list it in your terms and conditions.
Yeah.
However, if you're a hosting service, you're not. You are brought into those obligations that the medium-sized companies are. Is that correct?
Yeah. So you have to have the notice and takedown procedure in place. And this is effectively looking at content moderation. So if you are storing information and someone tells you that the information you're storing is illegal, it means that as a host provider, you need to take it down. I mean, that's ultimately what it boils down to. You would have this obligation today. So it's not increasing your obligation in that respect. If you have knowledge or awareness of illegality, you have to act on it or you lose the benefit of your exemption.
But you also have to give a statement of reason to the recipient. So that's another, like I'm thinking of a micro startup, one or two people, and they're going to have to respond to all of these issues.
And they're going to need to put a procedure in place for dealing with it. And it may be that as the legislation progresses, and I'm sorry, I digress for a minute, but just to mention, once this is passed, there will, at the moment, there's a planned year. There's a period of a year where organizations can really look at the finalized legislation and say, what does this mean for my business? And how can I comply? So your 1 and 2 person, there is some time there. It's not a cliff edge in terms of compliance. But I guess just because you're a 1 or 2 person business doesn't get you out of the host provider obligations in terms of statement of reasons.
And I suppose some would argue there should be proportionate. They won't have the same resources. But you did mention cliff edge, and that brings me nicely on to the next question about medium-sized businesses. There are 50 over.
Yeah.
They do get a cliff edge. When this comes in, if you have when you hit 50 employees, you are going to enter more obligations, and that you are going to have to comply with them from day one.
And there is also a turnover threshold there, which is relevant. I think the turnover threshold is above 10 million. Mm-hmm. So again, you see the DSA trying to make it proportionate to the value of the business, in terms of ensuring that the smallest providers don't have those increased obligations that apply to the medium-sized businesses.
But that would be a concern to a medium-sized business. I think that's fair enough, that if you suddenly come into the remit, you might, when not from inception, but after it's implemented, that in terms of revenue or in terms of staff levels, that you are going to hit those new obligations.
And I think that's why sessions like this are important, in terms of horizon scanning and making sure that startups are aware. I mean, I listened to something recently where a startup was talking about what's the benefit of lawyers in the early stages of startup life, because lawyers are probably the last thing you want to be investing in. And the relevant founder there said, while you're founder working on your product and developing it and looking for investment and working with really smart people, it's good to know that you have someone in the background who's looking out for what are the gotchas, what are the things you should be doing. And I think Scale Ireland, through this report and this session, is effectively providing that kind of service for the startups.
And there also are a lot of positives in relation to the country of origin being maintained, the liability exemption, and there's no obligation on general monitoring. Because startups wouldn't have the resources to do that 24/7.
They'd be crippled. You wouldn't have time to operate a business.
They have enough, I suppose, limitations and pressures. Can I ask you also, this is a very specific question, does illegal content include copyright notices like songs uploaded by someone other than the rights holder? Now that is very specific, so that might be one you have to come back to.
I might come back on that, and I suspect I know who I need to go directly to on that as well.
But I suppose that is an issue too on the definition of illegal.
Yeah, and it's not just the definition. So the issue on the definition of illegal is essentially, as it's defined at the moment, if it's illegal in one member state or EU law, it's illegal for the purposes of the DSA. So if I'm operating in Ireland and I get a notice about French law, how do I know whether or not it's illegal? And is it good enough for me to just take the statement of reasons provided by the individual submitting the notice? Is it good enough for me to just take that at face value and say, to my service recipient, because I received this notice, I'm cutting you off? What are the steps that the business will actually have to do to satisfy itself that actually this notice that it's received is valid for the purposes of French law in my example?
So what would that person do then if it is a complicated scenario, isn't it?
Yeah, and I suppose that there's no way of getting around that. The service providers have to be diligent in their steps in terms of responding to that notice. So I suspect just taking every notice on face value will not amount to having taken diligent steps. So there will be some measures that the businesses have to take of their own initiative to ensure that it's not unfounded, that it's not an unfounded notice.
And to be fair, one thing that I suppose this regulation contains, the proportionality. Obviously, they will take into consideration the size of the business, the resources, and the actions taken.
Yeah, absolutely, and I mean that's peppered throughout. But I suppose the point though is that even if you are even if you're a smaller business, you still have to be diligent in your efforts towards compliance.
Okay, brings us nicely onto costs.
Yeah,
how much is this going to cost startups? That's what they'll want to know at the end of the day. How, if you're small, if you're a micro, and obviously it depends if you're hosting service or not. What about the cost?
Yeah, so the costs from the European Commission impact assessment were for the takedown notice that you could incur one-off costs of 1,500 to 50,000. which is a huge variance for businesses, and ultimately that depends on the volume of notices that you get in terms of responding to them. And then the other cost that the Commission impact assessment gave was for medium-sized businesses. It suggested a cost of 400,000 annually for complying. But I suppose you need to contrast that against what are the costs that organisations that are seeking to comply with their current obligations have today. And the Commission's impact assessment is saying that those costs will be reduced. So while we now have some numbers because of the impact assessment that we can put against these obligations, I think to understand the value of it, it would be comparing and contrasting that against the costs that startups invest in these measures today before you can really understand.
Because on one side, I think you're right that on one side you have all the obligations and resources they have to put in place, but on the other, it's as opposed to navigating 27 jurisdictions.
Yeah, exactly.
So, and that is difficult. So I'm sure we'll hear more about clarity, because I'm sure Scale Ireland won't be the only startup representative organisation asking about that. Claire, to be honest, thank you so much. What a comprehensive, detailed analysis of a very complicated and weighty new regulation that affects startups in a real, many startups in a real and substantive way. And you've brought us through that effortlessly. So thank you very much for joining us today. We also want to thank the Minister for joining us earlier and giving us the government's perspective on this, and also to our chair, Brian Caulfield. Also, I can't forget that plug on our membership. If you are interested in joining the Scale Ireland community and having a voice, and also having a peer-to-peer group in our Slack community, please join us. Visit the website. And thank you for today also to our terrific hosts in Dogpatch Labs, who as always have done a great event today, and special mention to Sinead and to all our team, particularly Luke and Sheila. Thank you.